Welcome everyone to the final event in our series of space sustainability talks. We are Sichtraum, the Security and Technology in Space network of researchers. My name is Daniel Lambach from the University of Frankfurt, and with me is Maximilian Bertamini from the University of Bochum and Philipp Olbrich from the German Development Agency. And in our previous talks, we have talked about the problem of space sustainability, about the politics, about the technical issues, and we've already touched on some legal aspects when we had Rada Popova as our guest speaker. And this is a topic we want to expand on today with Erik Pellander, who's joining us for this event. The focus today will be on legal frameworks as the link between states and non-governmental actors, especially commercial operators. And our aim is to assess whether regulations and incentives and governance approaches in the areas of liability or insurance or procurement and the like could be useful tools for moving towards space sustainability. Erik Pellander is a research fellow at BHO Legal, and if I, as a non-lawyer, understand this correctly, BHO Legal is a boutique law firm, if I'm using this term correctly, specializing in several fields, among them air and space law, public procurement law, state aid law, and other fields, many of which are of great importance to the space economy. Mr. Pellander has been with BHO Legal since 2011. Before that, he has worked at the legal department of the German Space Agency, as well as for the Institute of Air and Space Law at the University of Cologne, where he also received his degree in addition to studies at the University of Bangalore. He's the co-author and author of several papers and books on commercial space activities, on international private law, and on international environmental law. Mr. Pellander, thank you very much for joining us today, and we are greatly looking forward to your talk.
Yeah, many thanks for the kind introduction and many thanks for featuring me today. I have prepared a short presentation, which I tried to share with you right now. So here we hopefully are. Can you see this presentation? Great. So turning to legal tools to ensure space sustainability. As an introduction, I have developed a graph which highlights the legal tools on space sustainability I would like to discuss with you today. On the left hand of the graph, you see those tools which are directed towards state actors or international organizations, or which at least have been developed in international fora. At the beginning, discussions on space sustainability were pretty much confined to those instruments directed towards state actors, as outer space activities were dominated by states. However, in recent times, the tools on the right side of the graph, namely national space law, as well as procurement and grant conditions, are of growing importance, bearing in mind the growing commercialization of outer space activities. What needs to be highlighted in this regard is that private actors are not directly bound by the frameworks directed towards state actors and international organizations. And therefore, there is a need to flow down these obligations and guidelines and standards to private operators through appropriate tools. Turning to the tools which are directed towards state actors and international organizations, these tools can be grouped into binding international commitments codified in international treaties and acknowledged under customary international law, and non-binding instruments, so-called soft law instruments, as well as technical guidelines and standards. When it comes to international treaty law, obligations on the protection and preservation of the outer space environment under the framework governing outer space activities are quite vague. Article 9 of the Outer Space Treaty obliges states to, I quote, avoid contamination and, where necessary, adopt appropriate measures for this purpose. At the best, this is an obligation of due diligence, requiring states to adopt an appropriate standard of care. However, how to determine the standard of care for such a vague obligation? Under general international law on the protection and preservation of the environment, there is a well-established set of rules acknowledged under customary international law. Just to name a few, the principle of sustainability, the precautionary principle, the obligation not to cause transboundary harm, or the obligation to undertake an environmental impact assessment. These principles and norms are applicable to common spaces such as outer space, which was already underlined in 1972 by Principle 21 of the Stockholm Declaration, which refers to areas beyond the limits of national jurisdiction and control when it comes to the obligation not to cause transboundary harm. And these general obligations under environmental law may serve as a tool to determine an appropriate standard of care to adhere to the vague obligation under Article 9 of the Outer Space Treaty. Or, in other words, they may serve as a tool to determine where it is necessary to adopt measures to avoid contamination of the outer space environment and which measures are appropriate. When it comes to non-binding instruments at international level directed towards state actors and international organizations, we have on the one hand so-called soft law instruments, and on the other hand, technical guidelines and standards. As for technical guidelines and standards, the most well-known instruments are probably the ILSC Space Debris Mitigation Guidelines, as well as the ISO standard on space debris mitigation. Some of these guidelines have been transformed into so-called soft law instruments at international level. The most prominent example are the UN Corpus Space Debris Mitigation Guidelines, which have been endorsed by the UN General Assembly in 2007, and which are based on the ILSC Space Debris Mitigation Guidelines, though they are much more high level. The guidelines on the long-term sustainability of outer space developed by Corpus are another example for soft law instruments on space sustainability. As nowadays, international lawmaking is more and more confined to norms of recommendatory nature, these soft law instruments are the most likely tool to ensure space sustainability. And I'm not arguing that they are the best or the ideal tool, which are probably binding international commitments on protecting and preserving the outer space environment. However, in the light of the current geopolitical environment, they are the most likely avenue to ensure the long-term sustainability of outer space. As already highlighted in the introduction, private actors are not directly bound by these principles and norms developed at international level. As, to say it in legal terms, they are not subject to international law. Accordingly, states are required and even obliged under international law to flow down obligations on the protection and preservation of the outer space environment to private actors through appropriate tools. National space legislation is in this regard the most effective tool to flow down such obligations. And in addition to flowing down binding obligations under international law, national space law is furthermore a tool to give legal force to non-binding guidelines on space sustainability by making it mandatory for licensees to act in conformity with these guidelines. Some national space laws make general reference to commonly accepted standards, others refer to particular instruments, whilst other states have developed their own space debris mitigation requirements at national level. At the same time, national space law is, however, more and more considered as a tool to attract business, and there are growing concerns about a race to the bottom when it comes to requirements on space debris mitigation or even space debris remediation. However, on the one hand, it is questionable whether requirements on space sustainability are to be considered as a stumbling block for business, as the costs of non-compliance with these requirements are much more higher for commercial operators than the costs for complying with these requirements. Or to say it in other words, the costs are much higher for operators when in the long term or even in the near future, according to some experts, some orbits will not be usable anymore. And further, licensing requirements on space sustainability might even be an enabler for business. Let's take the example of on-orbit servicing and active debris removal, which are a need for ensuring space sustainability. When licensing authorities make it mandatory to employ such techniques for licensees, this would be a real market push for companies offering such services. Tools on ensuring space sustainability through national space legislation are not limited to setting requirements on space debris mitigation or remediation under national law. Another tool which can be applied are incentives through liability and insurance requirements. These requirements are regularly set in accordance with the risks associated to the activity in question. So, to say it in easy terms, when the sustainable use of outer space decreases liability risk exposures, the costs for complying with requirements on liability and insurance for operators shall decrease at the same time. Liability and insurance requirements can thereby be a powerful tool to incentivize practices to promote space sustainability, and some licensing authorities are already considering such an approach. Like the UK, which is currently reviewing their policies and has announced at a presentation at a conference a few weeks ago that they are currently considering this matter. As already highlighted above, on-orbit servicing and active debris removal is a need to ensure space sustainability. And a clear and predictable legal framework on these matters is key to ensure the uptake of these endeavors. However, licensing procedures under national space law were not developed for these kind of activities, which were not even known at the time when they were drafted. And even if these activities might, in principle, be covered by licensing schemes under national space law, they are not yet adequately addressed. To provide for an example, in the US, initial demonstrator missions on on-orbit servicing required, on the one hand, a license from the FCC, which is not that surprising, as this is the standard practice for in-orbit operations. However, on the other, they also did require a license from the NOAA on the operations of a remote sensing space system, as the payload, the optical payload, which is used for docking, formally falls under the scope of this licensing regime. So they do not undertake activities for which these frameworks were drafted, namely taking picture of the Earth and not taking picture of a satellite to be docked through an optical payload. In Europe, as well as in the US, there are currently operational standards under development, which may be an enabler for developing appropriate licensing schemes on this matter. Another tool, in addition to national space legislation, which is often underestimated, are procurement and grant conditions. as the space sector is still largely driven by public money. So in easy terms, if a private operator wants to have access to public money, they need to adhere to requirements on space sustainability. Contracting authorities could, for example, ensure that that a tenderer meets requirements on space sustainability in procurement procedures or in grant procedures by excluding a tenderer from a procurement procedure who is non-compliant with guidelines and standards on space sustainability. They may also set evaluation criteria in a way which take into account adherence to space sustainability requirements or even overperformance in this regard. The terms and conditions of the contract or the respective grant agreement may also set conditions on space sustainability. In contrast to national space legislation, which is subject to often lengthy legislative procedures, even for amendments, procurement and grant conditions, as well as the terms and conditions of the contract or the grant agreement, can be set up rather quickly. And they might be applied even in absence of national space law. So, in summary, some tools to ensure space sustainability are directed towards states or international organizations, whilst others are directed towards private actors. As for state actors, international environmental law may fill existing gaps under national space law. And nowadays, international lawmaking is confined to soft law instruments, which are the most likely avenue to promote space sustainability at international level. As for private actors, national space legislation is the most effective tool to flow down obligations under international law to private operators and to give soft law instruments legal force. Liability and insurance requirements may set incentives for ensuring space sustainability. A clear and predictable legal framework is a need to enable endeavors such as on-orbit servicing and active debris removal. And last but not least, procurement and grant conditions, as well as the terms and conditions of the contract or grant agreement, are a powerful tool for ensuring space sustainability. In summary, there are plenty of tools available for ensuring space sustainability. It is just up to the relevant stakeholders to apply them. And thereby, I would like to conclude my presentation and thank you for your attention. And I'm very much looking forward to discuss these matters in further detail.
Thank you very much. I have so many questions. But first, for our listeners, if you want to ask a question, there are three options. The first is with both video and audio. The second is just the audio. And a third is if you would prefer not to appear in person, you can just write the question into the chat. If you would like to exercise options 1 or 2, please just write the number 1 or the number 2 into the chat and I will call on you. Now, as I said, I have a lot of questions, and Maximilian and Philip, feel free to add yours as well. So I'll just respond to one of the things you mentioned in the presentation. It's a kind of a specific thing. I really like how your presentation basically showed us the problem of getting people to act in a more sustainable manner, sort of from the bottom up rather than from the top down. I mean, we've all engaged in this kind of, oh, the 5 treaty system is so old and so full of holes and it doesn't cover all the relevant aspects, and that's all true, but apparently there's so much more that can be done with the tools we have. Now my question is it being used that way? And specifically about the procurement guidelines and grant conditions you discussed at the end. You said that this is a very flexible tool through which sustainability standards could be sort of enforced on private companies who are the recipients of grants or who wish to engage in these procurement decisions. But are they actually used for that purpose? Do state agencies do that in your experience?
Yeah, well, as for the first point mentioned by you, bottom up versus top down, I'm not arguing that a bottom up approach is much better. However, bearing in mind the reality, it's the most likely avenue in order to ensure space sustainability. And turning to the second part of your question, well, I'm not in the position to reveal any details on procurement procedures we provided legal advice on. However, to my knowledge, these measures are applied by contracting authorities. However, they can do more in this regard. One prominent example where it's already done are the ESA rules on space debris mitigation, which were, among other matters, drafted for the purpose that when ESA is procuring, they shall ensure adherence with these requirements. And at national level, there are further several projects in this regard, but this is not necessarily limited to licensing authorities in the space sector, as there are many contracting authorities which are not necessarily space agencies or whatever. Let's take the example of maritime authorities which are procuring Earth observation services and so on and so on. And I'm pretty much sure that when they procure space service, they are not even aware of the requirement on space debris mitigation and so on and so on. So as regards procurements undertaken by space agencies, at least to my knowledge, it is taken into account, at least to some extent, though agencies can do more. What is, in my view, much more an issue is that space services are not only procured by contracting authorities which are engaged with the space sector.
Mm-hmm. Well, that's an entirely new issue for me. And it seems to be something, I mean, in our talk with Klaus Schildknecht, we talked about the problem of sort of mutual learning between policy and legal communities in different sectors, maritime law and space law and air law and whatever. And he said, well, in policy terms, there could be more contact between these communities to sort of exchange on this. And this seems to kind of reinforce that at least a little bit. Now, as for another point you made regarding the common complaint about the risks of a race to the bottom, the typical complaint goes like this: if we institute tough sustainability standards, our space sector will suffer in comparison to its international competitors. And you argued against that, and I like this position from a normative perspective. That, and I think your argument was that the costs for non-compliance are higher than the costs for compliance, because if too many people don't comply, then orbits will become unusable. But I want to push you on that a little bit, because isn't there a difference between sort of private costs and public costs of non-compliance? So in a completely selfish scenario where one actor decides, to hell with whatever happens to this particular orbit, I want to maximize my personal payoff. Could we not see the problem of a race to the bottom anyway?
There definitely is a race to the bottom, and we are partly witnessing it already. However, my argument that the costs are much higher does, in my view, not only apply to public actors, as these orbits will not be usable for private actors too. And some experts even argue that this will occur in the short term. So we are not even talking about, long-term business will not be possible anymore. We are talking about consequences in the short term, which will also affect private actors which want to use these orbits. Mm-hmm. So but for sure, there are many operators which do only see the costs of compliance and which do not take this into account. What I did like a lot was a quote from a colleague of mine at a UK conference a few weeks ago, where she was arguing why we are all the time talking about the race to the bottom and why we are not talking about the race to the top and why it should not be attractive for a company to be located in a state which acts responsible. Well, I'm not in the position to judge on it and to say whether it's particular true, but I did pretty much like the idea about why we should not engage in a race to the top and why this acting responsible should not make a state attractive in order to be located there.
I think that's a very good point, but it would take us into a discussion of how do we provide incentives to engage in this race to the top. Maybe more on that in a second. Since we're talking about the private sector, in our talk, I think it was with Tomasz Rosensky, he said, well, his impression overall is that business appreciates a clear legal framework more than legal uncertainty, but more freedom. On a very general level, do you think that holds up? Is your impression that commercial actors in the space sector would welcome a bit more regulation if it gives them a bit more certainty, even at the cost of making operations a bit more expensive?
I think it's true, because that predictability is sometimes much more worse than, let's say, I have 10 or 100K more or less costs, as long as you can predict the costs in advance. When we are, for example, talking about liability and insurance requirements, they need to get in touch with insurers and they need to get an insurance. And as long as this is not clearly predictable for you, it hinders your business. And even more when we are talking about investor relations, because investors want to assess the risk in advance. And when you do not have a clear and predictable legal framework, for example, when it comes to on-orbit servicing and active debris removal, investors are afraid of investing in a business where they cannot clearly assess the risk in advance, as we are lacking a clear and predictable legal framework.
So in a way, more regulation could actually be beneficial for the sector because it might attract more investors, or it might drive down insurance costs.
Yeah, or let's take the example of Germany. We have a growing commercial space sector. However, we are lacking national space legislation, and we have witnessed on several occasions that German companies are struggling when it comes to investor relations, because they can not tell them anything about the legal risk. Instead of, well, there might be a national space law in the near future. However, we cannot yet fully assess the costs or risks associated thereto.
Well, the national space legislation in Germany has been sort of an ongoing issue for the past few years. What would you like to see there? I mean, there are many proposals already sort of floating around, many ideas. Where do you think this should go? Do you have anything you would like to sort of raise our attention to, where you think that this is a crucial but maybe underappreciated bit of this legislation?
Well, first of all, what you mentioned, that predictability is much more important than freedom, because some government representatives still argue that it's a perfect situation for private operators. They can do whatever they want. So why we shall adopt a national space legislation? Yeah, well, and apart from this, from a business perspective, it shall not have undue burdens in comparison to other jurisdictions. And it is a chance that we are latecomers when it comes to national space legislation, that we can take into account new developments in advance such as on-orbit servicing or active debris removal, or incentivize sustainable behavior, which is discussed currently in many states which are discussing amendments. But it's much more easy to take such matters into account when you're start to develop a space law from the scratch than when you are discussing amendments.
Right. Again, let me remind our viewers that you can ask a question if you want, and I'll also look towards Maximilian and Philip if there's anything they would like to raise. Maximilian, you gave a nod there.
Yeah, I don't want to take the opportunity away from the viewers, of course, but unless somebody raises a question, I would indeed have one that I would like to raise, namely, my impression is that national space legislation has to overcome two gaps, essentially. The first gap is what I would call the subject gap, in terms of making private actors bound by something, which international law as of yet does not provide. And the second gap is then the content gap, because on the international level, there might be some vague rules, but in terms of what standards exactly should be applicable is something that national legislation would have to figure out as well. So that's a lot to ask from legislators, I would say. And I'm wondering whether relying on national legislation as a solution doesn't come with the danger of, let's say, fragmentation of sustainability standards. And in that light, I would be very interested in your take on whether it is to be preferred to have a universal sustainability standard that is applicable to private actors, despite probably on a rather low level of standard, or whether you would opt for a system where nations go and do their own thing, and some nations might have a higher standard applicable for their space companies, others might have a lower standard applicable. Just what would you prefer in that regard? And maybe do you think that regional solutions, for example, on a EU level or for the League of African Nations or the Arab League, could be a promising, let's say, compromise between the two positions of universality and the height of standards? Sorry, that's a long question. I'm happy to repeat any part of it, but I would be very interested in your take on this.
Yeah, as regards the first point, that it is a gap that nations need to flow down obligations under international space law to private operators. In my view, it's not necessarily a gap. It's a basic principle of international law that privates are not bound by international law, and that there is a need to flow down this to private operators, and that in contrast to other areas of law, in space law, we at least have the privilege that all kinds of private space activities are directly attributable to a state. So there's much more pressure to regulate these activities than in other areas where activities of non-governmental entities might be attributable when a state has effective control, or according to another view, as overall control. As regards the point that nations tend to do their own thing, that's true, that we have a various level of implementation at national level. And in an ideal world, we would have much more binding or detailed rules at international level, which would ensure a uniform level of adherence. However, again, as with the discussion on bottom up or top down, it might be desirable. However, in the current environment, we need to deal with partly fragmented bottom-up approach. And I would not be that pessimistic, as well as highlighted in the presentation. We have non-binding guidelines at international level to which states are not even bound, which have been made mandatory at national level, which is quite unique. I think that states overperform when it comes to their international obligations. Well, there is no hard obligation under international law to adhere to these guidelines and standards, and nonetheless states to implement these guidelines of standards. At the same time, I'm acknowledge that the various levels of implementation and the differing rules at national level are hindering a uniform approach on space sustainability. As regards the question of regional initiatives, well, I cannot talk about the African Union because I do not know that much about their frameworks. Well, at European level, we all know that the European EU framework excludes any harmonization at EU level, and that's what we need to deal with. Okay, it's not prohibited to have coordination at European level or even through other international fora. However, there were good reasons why the EU member states did not want any harmonization at EU level when it comes to national space legislation. And that is what we need to deal with. So it might be desirable to have a more harmonized approach.
If I may latch onto that last part about the European Union, what's the role of the European Union's of EUSPA, the EU Space Agency? I think it's called. I mean, given the limited capacities of the European Union to do anything meaningful in this sector.
Well, EUSPA is the program authority for the European Space Program. Before it has been the GSA, the program authority for Galileo, and under the new space program regulation, it's the program authority for the EU space program, namely Galileo, Copernicus, GovSatcom, SSA, and probably some new program component on secure connectivity. But that's it. What is the competence of EUSPA? It's quite broad when it comes to the European space program. However, the influence is limited to the components of the European space program, and well, they may impose obligations on space sustainability when it comes to their procurements in relation to the European space program. But that's it. In addition to it, each and every spacefaring nation in Europe has its national program, and it's up to them to regulate this. And each and every jurisdiction within the EU has its own national operators, and it's up to the respective member state to authorize and supervise these activities.
Mm-hmm. I have several more questions, but they tend towards the big picture kind. Philip, please.
Yeah, I don't have big picture questions. only tiny pictures. And I also would like to stay on that topic a little bit, because I would like to know from your perspective in how far this also is, basically location politics, to be attractive as a country for space businesses, that people are reluctant to go for harmonization on an EU level, but also on an international level. And then also, if national space law is so relevant to regulate this, I would be wondering if any political party, either in Germany or in other contexts, has taken up this topic. I mean, in Germany, elections are in September, and most of the programs are out. Does space play a role in there? And if so, how?
So, pardon me, you rephrase the second part of your question?
Yeah, the second part would be the programs, the political programs of parties in Germany now ahead of the elections. If space plays a role in there, and space sustainability in particular.
Well, as regards the political programs, we're in touch with the representative of one party where it was not in the program, but on the so-called backup list. it's yeah, not that prominent as one may imagine. As for the first part of your question, as these lack of harmonization clauses out to the fact that states wanted to have national space legislation as a tool to attract business. Well, when the current EU legal framework was drafted, to my knowledge, national space legislation was not that much considered as a tool for economic development. There was a limited commercialization, and it was rather considered as a tool to adherence with international obligations, security implications, and so on and so on. And even later on in 2015, as far as I remember, we did undertake a study for the European Commission on national space legislation in view of growing commercialization. And even then, there was the outcome that in the current environment, national space legislation is not yet that much considered as a tool to attract business, and there is not yet that much a risk of the race to the bottom. So that national space legislation is considered as a tool to attract business is rather a recent development which came together with the so-called new space wave. However, at the time when the EU legal framework was drafted, national space law was primarily considered as a tool to ensure adherence with international law, to ensure security implications, and so on, which has the national dimension. What is also should also be taken into account in this regard is that under the Outer Space Treaty, it are the member states which are obliged to authorize and supervise space activities, and the member states bear responsibility and not the EU. And the EU cannot even bear responsibilities for these activities under the Outer Space Treaty. And this is also one of the main arguments why it should still be a national competence, because why the EU should regulate something for what it in itself does not even bear responsibility. These are the member states which bear responsibility, and the member states are obliged under the Outer Space Treaty to authorize and supervise national space activities, and not the EU. So these were, to my knowledge, at this time, the key arguments for the non-harmonization clause, and that national space legislation is considered as a tool to attract business is a rather recent development.
Yeah, I want to echo that point about space having a rather low profile in the current election season. Although maybe the times they are changing, because you might recall this high-profile Bavaria 1 program with the Markus Söder photo op, I think it was 2 years ago. And also the BDI, the Association of German Industry, has also started to position itself very much in this issue. Although this hasn't really been picked up by the political parties, if I view this correctly. Now, Max, you do have another question?
Yes, I do, and in fact, it's a little bit more of a comment. But I've been thinking about this quote you mentioned by your colleague, namely that we should maybe start thinking about space sustainability as a race to the top. And I was wondering how that might work. And I've been thinking, and this sort of picks up the discussion about politics, I guess, that sustainability and many other ideas that could be associated with green politics have gained a lot of traction recently and have a lot of momentum behind them. And I think this can not only be seen in politics, but also in the behavior of consumers. I have the impression that many powerful companies and many industries pride themselves on offering sustainable solutions. I mean, Apple claims they recycle a number of components of their phones. Energy providers claim that they use so and so many percentage of green energy. And I think making the space industry accessible to everyday consumers might be a powerful lever to get the space industry concerned about offering sustainable solutions. I don't know if that's a realistic assumption, or if the products, so to say, offered by the space industry are even apt to give consumers access to them and have them make a choice, which providers, which satellites to use in their everyday business. But do you think that would be a route that would be worth thinking about, or is that something so far away from the everyday consumer that this is maybe too naive of a thought?
It depends whether the company really offers services to consumers well. Some kind of businesses are still confined to governmental clients and so on and so on, whilst other downstream services are directly related to consumers in the narrow sense. So when companies are offering services to consumers and not just to governmental entities, for sure environmental concerns are of growing importance, and it might be a way to promote their business well. Planet is, for example, when you take Planet, they are promoting their business by stating that they want to make the Earth more sustainable and so on and so on. So they all are already tensions. What might be another tool in this regard for a race to the top are the most recent space sustainability ratings, which have been announced at the World Economic Forum, which might be another tool in this regard. So yeah, when it comes to end consumers, it depends whether the company is really offering services to end consumers.
Yes, and to add to that, I was just thinking of a comparison, which would be the system of sort of licensing ships through flags of convenience, which would be an example of a race to the bottom, because shipping companies do like to register their ships in low regulation, low cost jurisdictions. So that seems to be a system where sort of the incentive structure hasn't worked in favor of higher standards. Right, now, I did say I did have big picture questions, and one of them you sort of invited with the last point on your slide is you did say there are plenty of tools available. And I was really grateful for that point, because I wasn't really aware of many of these tools. But the second part was that stakeholders need to apply them. Now, my question is, how do we get them to do that? Because my impression is that there are these opportunities, but they're used in a very infrequent kind of patchwork manner. How do we get more national, more states, more space operators to use the tools that are available?
Yeah, well, when it comes to the international level, we talk about the general dilemma of international law that we are lacking enforcement mechanisms instead of except of shaming and blaming. However, the more space sustainability comes on the agenda of the general public, the more shaming and blaming can be expected. And yeah, as already stated before, though there is a different level of implementations, nonetheless, already nowadays, states implement non-binding guidelines at national level. So I'm not that pessimistic, because the system partly works, so we do not have any binding obligations, and unfortunately, we do not have any other mechanisms than shaming and blaming at international levels, and have these lengthy discussions in international fora, and so on and so on. So yeah, I'm not that pessimistic that the tools which are available are not applied at all. However, states can definitely do more, and discussions should not be limited to those, let's say, classic tools like licensing requirements on space debris mitigation and so on and so on. But states should also bear in mind that there are many other avenues, like setting incentives under liability schemes, or like simply having a clear and predictable legal framework on activities which do promote space sustainability.
Now, I agree in the sense that I find it noteworthy and commendable that states are adhering to soft law rules and to technical guidelines, which from a purely legal perspective they wouldn't have to, but most of them do. So that's pretty good. On the other hand, we have learned that the sustainability problem is escalating quite drastically at the moment. We have seen the number of objects launched into low and medium Earth orbit increase several times over the past few years alone. We've seen the number of debris objects grow. And some of our guests have been a bit pessimistic about our chance to really keep abreast of the problem as it is developing right now. Now, my final question would be if we might be better off sort of putting the system on its head, because right now the entire system of outer space governance still feels very top heavy, still very much based on states trying to acting in concert if all things go well, and then sort of hierarchically trickling down regulations to act as within their jurisdiction. Now, in a paper, I tried to set out a proposal for a more polycentric approach to governance. And for example, this would entail private actors starting to generate rules amongst each other. One example that comes to mind is maybe the Space Data Association, an association of private operators, which were, maybe let me put it this way, they were so fed up with the quality of publicly available SSA data that they started generating and pooling their own. Might this be a way forward to kind of escape this, well, let's call it gridlock, or this slow movement of a more state-centered approach to outer space governance that we still have at the moment?
Well, there are already industry associations, and from time to time there are proposals from those industry associations on certain matters in relation to space sustainability. Yeah, well, this approach definitely, to put it in general terms, has its pros and cons, as long as develop minimum standards at industry level is not used as a tool to decrease the level of protection. It's for sure an avenue which is much faster than regulation at state level. At the same time, these tools can be used to escape regulations at state level by arguing, yeah, well, through self-regulations, we will be much faster, and at the end, it turns out that the level of protection is lower. So yeah, it's a tricky question. Yeah, in general terms, so industry self-regulation in other branches regularly tend to lower, or sometimes tend to lower, the level of protection rather than offering a higher level of protection. But as long as private entities are aware that it is a need for space sustainability, for sure it's most welcomed to have industry initiatives. And I already witnessed several statements from the industry that they are willing to do so. A part of this, there are consulting procedures with the industry, both at international and national level, to engage industry in lawmaking processes. So there's definitely much room for improvement.
Yeah, and that's a really good point about consultation processes, because we tend to not see those at the very top level where things happen at UN COPUOS, which is, of course, a state-dominated institution. But this would be another example of polycentricity, just building networks across the entire field, sort of in a more horizontal way of dialogue and coordination. But we'll have to see about that. Maximilian, Philipp, Does any one of you have a final question? Not seeing anything. Right. Well, thank you very much. This has been a really interesting talk, and I learned a lot about sort of the nitty-gritty of how states and private actors work together, and the many ways that these relations could be governed and could be steered in a more sustainable direction. And sort of to get back to my own question, how do we get actors to use these tools more consistently? I think you made the very important point that they respond to public pressure and that they respond to public scrutiny. So there is a lot more scope for holding our representatives accountable in this regard. Mr. Pelander, thank you very much for joining us. To our listeners, thank you for being with us today. Of course, the recording of this will be available within the next few days. And I wish everyone a good evening and a good rest of the week.
Yeah, many thanks for featuring me.
Thank you for being with us.
Bye.
Bye.